first case on this morning's docket. That is case number 111082, Cregan v. State of Kansas.
May it please the court, my name is Charles Millsap. I represent the state of Kansas and the secretary of its transportation department. Chief Justice Nuss, may I reserve 5 minutes of my time for rebuttal, please?
5 minutes is granted.
Thank you, Your Honor. This is an appropriate day to hear this case because it's my client's birthday. 155 years ago today, this state became a sovereign. And that's not only an interesting fact, it's relevant to this case because on that date, the power of eminent domain for my client came into being. It came into being in the entire state. It came into being as it relates to these pieces of property that we will talk about today. We know this is a case of inverse condemnation. My client made some highway improvements in Johnson County on I-435 and US 69. Some of those improvements were made inside of what I'd call a covenant community, the recorded covenants of which are inconsistent with building highways at that particular location. And the plaintiffs whose properties lie elsewhere, but within this covenant community, whose properties were not touched, whose ownership, use, and control were not affected by this, claim entitlement to compensation because they've been deprived of the right to enforce these covenants on these few lots that the highway lies upon. What's interesting in this particular case is that for these pieces of property, my client's right of eminent domain sat on those properties for about 117 years before in 1978 the developer decided to record some restrictive covenants. It's also interesting to note in this case that an acknowledged purpose of those recorded restrictions were to protect, and I would say attempt to supersede, KDOT's expansion of highways into any of this land. It's not explicitly stated in there, but the record demonstrates, according to the plaintiffs, that's one of the purposes of recording this. So imagine, if you can, this, a developer or a group of landowners ultimately gets together and says to themselves, we own this land. We know that the land is subject to the state's right of eminent domain. We know that if the state were to come along and acquire a lot to expand these highways, whoever owns those lots will be compensated, clearly under eminent domain. But either the developer or the owners may say to themselves, what about us? We know we're near a highway, but we don't want the highway anymore near to us.
What evidence do you have that there was in 78,
yes, sir,
when the covenants were adopted, that they were an attempt to supersede KDOT's ability to acquire the property? Is that just a conspiracy theory, or is there some evidence to that?
No, Justice. I would refer the court to appendix page 71, which is page 1 of the pretrial order in this case, and the plaintiff's contentions. And I won't read them in the record, but I represent to you that they say what I said.
That was the part of the design of establishing these covenants were to protect all property owners from
not
this.
Verbatim, but a purpose of them at the time of recording was to protect against the possibility that KDOT might expand its highways into this property. That's the plaintiff's position that they presented to the district court. So these property owners say to themselves, if our lots aren't taken, but we end up with a highway closer than we want to be, perhaps if we record these restrictive covenants, years later when this occurs, even though we keep our property, we're not hindered in any way in our ability to own it, to control it, to alienate it, to sell it. And all that would ever incur to our property is potentially a diminution in the value of the property. Nevertheless, if we record these at this time, decades later, we may be able to make a claim for compensation,
Counsel,
which is
Let me
Yes.
stop you there. You've said a couple of times that they didn't lose anything in terms of the property. And when you talk about that property, you're talking about the dominant property.
I'm
Their
talking about the
property
real
on
es-
which they live.
Yes, Justice, the real estate.
But they did lose their ability to enforce the covenants on the subservient property, the property owned by KDOT, didn't they?
They did if the use is an eminent domain use by my client.
Well, they no longer have the right to enforce those covenants on that property.
That's
Isn't that right?
correct. Right.
I mean, for all intents and purposes, what they got out of those restrictive covenants vis-a-vis those properties has been extinguished, has it not?
They have, to the extent there's an eminent domain use going on there. I would point out, and it won't totally satisfy the plaintiffs, but if you looked at a Google Earth of this area right now, all the construction pad is gone, it's green area, but the pavement obviously lies where it lies. I would propose to the court if I could convince KDOT to sell me a majority of the lots they previously bought back, since they end up not using it for payment, and I bought them, those restrictive covenant rights that the plaintiffs have would still be viable and would be sitting there preventing me from doing anything other than building homes like they have there. And they could, as the court has often said, could go to court and enforce those in an injunction action without even the need to prove irreparable harm, which we normally have.
That was a part of what they bought when they bought their properties that they live on.
Yes, Justice, that's
Okay,
correct.
all right.
From my perception, I think the case somewhat got derailed in the Court of Appeals by obsessing over the issue of what are we going to call these restricted covenant rights to keep some land away from my property from being put to use for something other than residential, or in this case for highway improvements. And you can call it a property right, you can call it a contract right. It is literally a matter of private contract right to create these. But we don't quarrel with what the district court said here, which is that these restrictive covenants are created in a creature of contract, but the district court acknowledged itself that they can involve property interests in real property. We don't quarrel with that. We don't contest.
Does it matter whether they're real property versus another kind of property right? A contract right is a property right, isn't it?
Right. Yeah.
And the state can't take a property right without compensation, can it?
Agreed. Yes, ma'am. I would ask that at this point that the case not get derailed with an attempt to try to pigeonhole this as something, because to do so overlooks, which I think the Court of Appeals did, everything else we know about inverse condemnation in this case. And there's two things I want to quickly point out. One is what I'll refer to as the tangible property requirement, which is a living, breathing part of condemnation law in this state, and we can see that in the Cow case, Kirkpatrick and Foster, which generally stands for the proposition that compensable taking requires the government acquire possession and control of tangible property to the exclusion of the owner. And as we argue, to the extent you want to call the right of one of these homeowners to prevent these easternmost lots from being used for highway pavement as property, we suggest to the court that that's hardly tangible property, which we were in a position to take. And we would ask the court not to read that requirement out of the plaintiff's inverse condemnation claim. The other important thing that I would ask the court to keep in mind is that there's a physical taking requirement, which the district court, from our perspective, obviously we want you to return to that, but we believe the district court nailed that particular aspect. That is that, as indicated in Kirkpatrick, the EDPA, our state statute, defines actions for which compensation is required, and this court has said that the plain language of that statute states that compensation is required for physical taking of property interests and damage.
But the EDPA can't do less than what the Constitution requires, can it?
I agree, and I think one interesting aspect of this is a pure Fifth Amendment taking, where we really don't even need to read the state statute, or is it part of the expansion of eminent domain law by our state statute? And I would suggest to you, as I think the concurring opinion did, that if this was a pure Fifth Amendment taking, we wouldn't be able to find a dozen or more places in this United States where it isn't a compensable taking. There would be no explanation for how, over a period of 100 years, that could exist if this is a pure U.S. Constitution Fifth Amendment question that has to be answered in one way.
There is an explanation. They're wrong.
Okay.
Isn't that an explanation?
Well, it could, obviously it could be. I won't quarrel with the court that is a possibility. What we would like to emphasize in this particular case is what the court has said in Foster and Kirkpatrick. That is that our legislature is free to determine what is meant by the word taking and what shall be compensated by the reason of taking. And therefore, we ask the court to look to the EDPA and ask itself this: can we read that set of statutes and conclude that the state of Kansas intends to allow someone with an intangible right like these plaintiffs have to get notice of, to be labeled as an interested party, and to be compensated for in an inverse condemnation case? And we go through it in the brief. If this court were to accept the idea that these intangible rights are going to be compensable taking, we believe that would result in a wholesale amendment of several portions of the EDPA, which we would urge the court not to do. May I reserve the rest of my time?
You may. Do we have any further questions of counsel?
I do, just for a moment. I just wanted to give both sides an opportunity to talk about Judge Atchison's analysis and his concurrence, and how that would work as a practical matter, if you think it would work at all.
Well, from my client's perspective, practical is not the word that we would use, because I decided not to do the chicken little approach on this, that the sky's falling, although my client would feel as though it might be. We perceive that it would be totally impossible for my client or some other condemning authority to do anything in a situation like this if you accept this as a compensable taking, other than to order a title opinion and have the appraisers look at it, and then proceed with condemnation actions against every person that has a recorded contractual right to restrict the use of the property we're going to use, whether it's for a highway, a power line, or anything of the sort. So I don't think I overstate my client's position to say that it would be an impractical nightmare for the court to accept what's proposed by the Court of Appeals in this case.
Do I understand you? That would be a criticism you have of the Court of Appeals majority opinion as well.
Absolutely.
Yeah,
Yes.
that's what I thought. I was trying to focus a little bit more in on the hybrid approach suggested by Judge Atchison, because it sounds like to me that in a condemnation proceeding, then you would need a preliminary evidentiary hearing, even before the appraisers get to work.
Right. It would be a whole new world for us, which we hope doesn't occur.
Any more?
One more question, just
Sure.
one. You made a reference to the availability of injunction. For example, if this kind of border section between where your clients have their property and where KDOT has made use of the lots were to be sold back to someone, that person's interest would then be burdened as it was before by the restrictive covenants, and then an injunction might be available for a violative use. So that's all the lead up to the question, which is an injunction the only remedy for a violative use in Kansas?
Well, for the Persimmon case, which followed the previous one that the appellants rely on, it appears to us, based upon the fact that in that case the court said that you don't even need to prove irreparable harm, that if merely all you attempt to do, rather than claim your own real property has been damaged, is to assert your contractual right to stop someone else from doing this, that we believe that is the right that you have, is to go seek an injunction.
You think it's exclusive, just from reading between the lines of Persimmon? We don't have a case that says it's an exclusive remedy, do we?
I wouldn't say it's exclusive, because
Okay.
as evidence in this case, these plaintiffs originally had a nuisance claim, a trespass claim, and other remedies if they actually suffer damages that support a claim like that. But if their own real person or their own real property is not harmed, that they haven't lost any right to control or use, and all they claim to have suffered is a diminished value because I've lost the right that I had contracted for to force you not to do something on your property, then it would appear to me that injunction would be the remedy for that.
I understand your position that they haven't lost any right to control or use of their own property, the property on which they live. But they have lost a right to control or use of the subservient estate, haven't they? That's what the restrictive covenant gave them, and they no longer have it. It is extinguished for all intents and purposes, as long as KDOT holds the property.
It's extinguished on my client's properties where they've
Right.
constructed.
And they did have a
them.
right having to do with those properties before all of this started. That's what
Right.
they bought when they bought
Yeah.
their land.
Right.
Okay, thank you.
Thank you.
Any further questions? Thank you, counsel.
Doug Patterson, if it please the court. Justice, I will get back to a comment on Judge Atchison's concurring opinion, which I frankly believe was one of my best judicial reads ever in 40 years of practice. But let me begin my suggestions by describing what I believe this case is not. This case is not a Kirkpatrick case. KDOT argues that, well, we didn't have an actual touching. As a matter of fact, in their supplemental brief filed after we responded to their brief, they say, see, they've admitted, the property owners have admitted that they weren't touched physically, that they didn't have actually anything taken. And so they don't fall within the Kirkpatrick versus Olathe case because in Kirkpatrick, the planned or inevitable result of the stormwater project that Olathe undertook was to flood Mr. Kirkpatrick's property. That's right. We weren't flooded. We weren't damaged. We physically weren't touched, and therefore this is not a Kirkpatrick case. There are cases that are cited in the KDOT brief that talk about Cow and McDonald, lack of access, more inconvenient access taken as a result of KDOT or a condemning authority. This is not a Cow case, a McDonald's case. Your rulings in those cases were clear. Those were exercises of police powers that did inconvenience property owners but didn't take a property interest. This is not a Cow McDonald case. This is not a Persimmon case. This is not two property owners arguing over a homes association and a property owner arguing over a fence. Although we like Persimmon because it describes a protection provided in a restrictive covenant as a property interest, but the holding in that case, which interestingly was a couple years after our main case that we're relying on, the Reno Asset Management case, Persimmon in 2003 said you don't have to have irreparable harm to seek an injunction in a violation of a restrictive covenant matter. Now, this is not a Persimmon case because we didn't file an injunction. We didn't file an injunction because of the ruling of Reno County versus Asset Management. This is a Reno County versus Asset Management type of case. As you know, in that case, restricted lots, homeowners had homes, and the county decided to build a water tower within the subdivision on a restricted lot. In that case, the property owners sought an injunction. On paper, Justice Breyer, that remedy is available, injunction. But in that case, the Court of Appeals properly reviewed the four elements of an injunction. Number one, was there irreparable harm? Two, was there no remedy at law, and therefore equity had to be applied? An equity balancing issue and public purpose. Now, again, on the first item, whether there was irreparable damage that had been proven by the property owners due to the water tower, The court really didn't wrestle with whether there was irreparable damage, although 2 years later when Persimmon was decided, we now know that irreparable damage in a restricted covenant case in the face of an injunction is not necessary. They didn't deal with it. Maybe it wasn't argued by the parties in the Persimmon case, in the Ash asset management case. Let's skip that second function of an injunction, but let's talk about the injury balance and the public interest. The court in asset management said, they saw an injunction. And when we think about the equitable power of the court to weigh the balances of the interests involved, we're going to weigh the balance in favor of the water district and the city in putting the water tower because the community needs water. Therefore, the property owners didn't fare well on those the items 3 and 4 elements of an injunction, but the court went back, circled around and said, and on the second consideration of an injunction, whether there is adequate remedy at law, the court said there's a property interest taken, and the property owners could have sought inverse condemnation. Now, the property owners in that case, as KDOT says here, that is difficult. It is burdensome. And the court said, when we're talking about equitable remedies, in this case, when we're talking about constitutional rights, expediency is not the test of who wins or loses. Expediency, and I'll call it the hassle factor of dealing with property interests, is not a consideration when Fifth Amendment considerations are in play. And therefore, this is an asset management case where the property owners in the instant case read the asset management case and said, you're right. We don't think we can enjoin KDOT, who are putting a superhighway and exit lanes through our lots, through the lots that are restricted. Asset management says we do have an adequate remedy at law. Injunction won't lie, and therefore we need to seek an inverse condemnation case. Now, I would submit, although there's no evidence in the record below, whether or not the developer of Grand Oaks really entered into a conspiracy theory of stopping KDOT build these highways on what in 1978 was Schweitzer Boulevard, a little two-lane road. Don't think that was the case. There's no evidence to the point of that. What we do have here is...
Well, is bad faith an issue here if it gets back to the summary judgment?
No, sir, it was not.
Well, I mean, on an evidentiary basis, but as a matter of law, is bad faith, would that be something that would be a concern to the court?
Absolutely. Bad faith in any litigation is a concern. But here we just had a subdivision. Developer came in, platted 65 lots along Schweitzer Boulevard, now 69 Highway. These lots were restricted, and the property owners I represent knew, based upon those restrictions, that there would be a buffer of at least 8 houses between them and Schweitzer Boulevard. So, I mean, it was no more bad faith than any developer who decides to develop a community, a subdivision, to provide for a restriction on uses, an anticipation of the size of houses to be built in the subdivision. Very standard covenants that someone's going to pick up the trash, someone's going to mow the common areas. This is like the subdivisions many of us live in. It's just a restrictive covenant, which the courts have described under the majority rule. And I really appreciate Judge Atchison's comment about the majority rule when he says, you got majority rule, KDOT cites the ALR sections, we're citing the restatement of torts, we're citing Nichols on eminent domain. He finally says, is anyone keeping track of all these cases? Under the majority rule, what I believe to be the rule of asset management, these restrictive covenants are a property interest much like an easement. It's on paper. Again, under Kirkpatrick, we weren't touched. We weren't flooded. But we had essentially a negative easement to know that those lots were going to be houses. And when Mr. Cregan bought a property in Grand Oaks, he knew there was going to be a buffer of houses between his house and, at that point, Schweitzer bypass. Condemning authorities condemn and name the holders of the dominant estates and easements all the time, even though an easement is a piece of paper that establishes a dominant and serving relationship. That's a property interest. If KDOT takes a common driveway or an easement driveway, in a condemnation case, they name the holder of that dominant easement as a party in the condemnation case, and that easement is valued. Let's think of another piece of paper out there that is a property interest. My bank on my house doesn't occupy it, but it has an interest in it. It has a piece of paper file called a mortgage. And if KDOT condemns my house, they're going to name that mortgage company as a party. My clients hold a dominant negative easement over the lots that were owned by KDOT, that KDOT acquired with eyes wide open as to the existence of these restrictions.
When you're talking about paper interests, essentially, and I understand your argument, but how do you harmonize that with or distinguish that from the requirement that the state points to that takings are not compensable unless they are physical takings of tangible property?
I wouldn't agree that that is the only taking that's compensable, a physical taking.
So what do you do with the language in some of our prior cases that says that?
Asset management is...
That's what
is
you're
it-
relying on.
Now, I think there's a good case to be made in that vein for us in Cow, in McDonald, because the court said just an expectation of access is not compensable. That's an exercise of police power. But here we have a recorded document that protects our property interests by imposing legal obligations, recorded obligations, public document regulations upon the lots that KDOT freely acquired, knowing these restrictions were in place.
You're just arguing that the articulation of the rule that compensation requires a taking of tangible property, a physical taking, that's just too narrow. That sounds to me like what you're saying.
It's too narrow.
Okay.
The airport cases where you have the airliners flying over airspace, at some point in time, you can't complain. This is leading me into Judge Atchison's concurring opinion, by the way, so I appreciate it. But there are many cases where I think the airport cases are a very good example. Not as good an example as we have when we have a recorded negative easement, but at some point in time, there's no touching other than on the ears that causes activity to be compensable from a condemnation point of view.
And just as a side point, can you confirm whether or not your clients were noticed up for the condemnation proceeding here?
Good point. There was never a condemnation filed by KDOT. KDOT acquired these lots, I think, from a church.
So because they were the owner of the lots, they didn't file any condemnation action.
That is correct.
Okay.
That is correct. Now,
Counsel, you made reference to an analogy a few minutes ago about the holder of mortgages on real estate
Correct.
is named as a defendant in a mortgage foreclosure action.
I'm sorry, I misspoke. They are named in an eminent domain action because they have an interest in the property. I mean,
And if they are not named, do they then have a claim that a taking
they would.
occurred?
They would. Or at least they still have a mortgage on the property. Mortgage companies are condemned out or named as defendants in condemnation cases to essentially scrape off their mortgage interest on their property. And from a practical point of view, a mortgage company will enter appearance in this case and make a claim for the debt that they have on the property that's the subject matter of the condemnation case.
So in your view, that is a property interest that they have lost and they would be entitled to compensation?
Only to the extent of the debt the mortgage secures.
But it's your argument that that is a property interest?
Yes, yes, yes.
And if I could just follow up with,
Yes.
with my earlier line of questions. Had KDOT been required to condemn real property because they didn't already own it, what's your position vis-a-vis whether or not your clients would have been required to receive notice?
They would have been required to receive notice. That now gets us into Judge Atchison's concurring opinion, which it's interesting. He describes the majority, the minority, the hybrid. Everything should have air quotes around it. The point is that under either scenario, the hybrid or the majority, and I notice my time has expired. May I finish the
Certainly.
question, Chief Justice? Under this majority rule, or at least there are a number of states that Judge Atchison acknowledges deem a restricted covenant as a property interest. Under the KDOT argument, there's a lot of hassle involved. There's a lot of procedures, but there was not cited by KDOT, nor cited by Judge Atchison in his concurring opinion, an uproar among these states, New Mexico, Illinois, about this is just a disaster, we can't deal with it. There's no outcry, there's no uproar about how this is just stopping the entire public works project. But he does come up with this hybrid. And basically in the very last page, on page 32 of the entire opinion, in his last paragraph, he says, the trial courts are going to have to sort this out. They do sort it out. At the current time, every district judge and litigant are challenged with the determination of who is an aggrieved party. There might be a controversy, but there may not be a case involving whether or not someone 2 miles away in a restricted subdivision that has 1,000 lots is interested. It takes money to litigate. It takes time. It takes expense. And so the trial court, is the gatekeeper of who has a case or not. Now, it's true. The DOTs of the world and the counties in Kansas might have to do a little more homework. They might actually have to read their title insurance reports to get on the property they want to determine whether there are restricted covenants. If there's a homes association, they're going to name that homes association. There are cases out there reported where the homes association is a defendant in a case to condemn out those rights. Grand Oaks, there's no homes association formed. The identity of the property owners that are benefited by restrictive covenants are clearly known. It's a matter of record. Someone 10 houses away, 10 blocks away, are they going to hire an attorney? From a practical point of view, I agree with Judge Atchison when he says there has to be a gatekeeper. How are we going to sort this out?
But he's talking about something more specific. He's talking about differentiating between a real property interest on the one hand and a contract right on the other. And do you agree with him that that's necessary? I thought your position was that it didn't matter.
I don't
Okay.
think that's necessary.
You agree with your opponent that a property right is a property right is a property
Property
right.
and rights is property right. That's
Okay.
correct. That's
All right.
correct.
So this weaning or winnowing out to this separating the wheat from the chaff, you're not talking about doing it for that purpose. You're just talking about whether someone has a case that's more than de minimis.
I might be aggrieved, but but my damage is not provable. I mean, I'm not, I may.
Well, I'm confused then because I thought your position.
I just confused you.
Let's see
Yeah.
if you can unconfuse me. I thought that your position was that it's a property right, period, and that the loss of that property right, which is the right to enforce the restrictive covenant, why wouldn't there always be some damage from that? More distant from the property, you don't have any damage, even though you have the same property right as the person who's right next to the KDOT?
That's correct. In other words, in this case, I think the record contains the fact that KDOT's appraisals determined the value to be 0.
Right.
You can have a cause of action on paper, but you can have no damages.
Okay.
See, my concern in this argument is that, and we need to talk about Grand Oaks, that's what we're here, but talking about how many people are away, it brings me back to Reno County versus asset management, where literally you had a house and a water tower. The decision of this course, the decision of this court in Grand Oaks case is not a message in a bottle denying homeowners within Grand Oaks. It's the statement of the law of Kansas, of course. And so the facts of this case are important, but the facts of asset management are likewise important when a water tower was built within a restricted community. I appreciate, and again, I think Judge Atchison's concurring opinion is one of the best reads I've ever had. I was going along until we reached page 31 of it, of like page 19 of his concurring opinion. And I concluded by saying, we have, I believe, what Judge Atchison was describing is needed, not in terms of a contract claim versus a property interest claim, but a trial judge as the gatekeeper who has the ability to determine who is aggrieved or not, who is damaged or not, whether or not, well, I'll stop there. I believe the trial court is the gatekeeper of those type of decisions, and I think that's the safeguard we have at this point.
Do we have any further questions? Thank you, Counsel.
Thank you.
You reserve 5 minutes for rebuttal.
Thank you. Briefly, let me address a couple things that came up with the appellant. One, would these plaintiffs have received notice had we been required to commence an actual condemnation case? The answer to that is no. We don't have to guess. KSA 26503 tells us who we're required to notice, who must be in the petition. And it identifies and defines clearly for us who's an interested party in a condemnation action: owners, lien holders, and possessors. And this answers the second question that appellant counsel brought up, the mortgage company receiving notice. The mortgage company would receive a notice because it is one of the 3 parties the EDPA identifies as an interested party, a lien holder. Just very briefly, and I know this isn't a major issue, but back to the conspiracy theory question, I pulled out from the appendix, page 71, page 1 of the pretrial order, and I will just read it so that I have not editorialized and the court can hear for itself what the plaintiff said. The restrictions were intended to preserve the serenity of the plaintiff's residential property and protect plaintiffs from uses of any Grand Oak lots inconsistent with the
Why
restrictions.
does the intent matter? Why does their intent matter?
What I mention this because I think to allow this to become a compensable interest in the state of Kansas will encourage people to go do, and we've said this, maybe it's part of my Chicken Little thing, people would almost be remiss not to go get together and say to themselves, as I said when I opened, let's see to it that there's something in it for any of us if one of our properties
that same
is
exact
taken.
argument could apply to just in the world of traditional taking. I mean, people could get together and say, let's actually buy this property so we have a buffer. I mean, they are allowed to. That's not bad faith. That's just exercising property rights in a way that's thoughtful towards the long term, right?
Absolutely, I agree, Justice.
Okay.
Two more points that I want to make, and we haven't talked about it yet. We think it's clear, black letter, eminent domain law in the state of Kansas that mere diminution of value is not a compensable taking. And we appreciate how the appellants have attempted to deal with that, but that is this case. And it is this case because what my client did nothing to physically take any property from these plaintiffs to garner some tangible item, which is part of one of the two requirements of eminent domain that I've talked about here today.
Why does asset management not give the plaintiffs a cause of action here? I mean, as I understand the arguments we've heard today, the property owners are relying pretty heavily on asset management to say, look, we have facts that are on point, and the court said it's not an injunction, you have remedy at law to file an inverse condemnation action.
Right. Originally, when the appellants made reference to that case in their first brief, they acknowledged that that was dicta. That's changed as they became more enamored with the possibility of using that. But even as...
So rather than distinguishing asset management, you just are arguing that that's not the correct rule.
Absolutely. I don't think dicta in that case, in an appeal where it wasn't even clear what was being appealed, should take the place of the EDPA in this particular case. As a parting concept, I would ask the court to consider a finding which would be consistent with the following. Restrictive covenants, which are a matter of private contract right, should not be allowed to supersede or in any way affect existing eminent domain rights held by my client, the state of Kansas. My client appreciates the fact that this court accepted this petition for review. This is obviously very important to it and to everyone else that condemns property, and we look forward to the decision.
Was that your second point? You said you had 2 points, about the diminution in value, and then the second point is that, was that your
Yes,
second
sir.
point that restrictive covenants shouldn't trump
Yeah,
eminent domain?
Yeah, those weren't exact same points, but yeah, sure.
Any further questions? Thank you, counsel.
Thank you very much.
Thank you both for your arguments this morning. Court will take this matter under advisement.